She is a biology teacher accused of sexually abusing not one, not two, not three, not four, not five, but six students at her school. Prosecutors now say she allegedly took things a step further, blatantly violating the conditions set by the court. And fittingly for this case, you may be surprised by just how many times she is accused of doing it. We're on the case presented by Law and Crime. I'm Chris Stewart. So based on the sheer volume of allegations, this may be one of the most disturbing teacher sex abuse cases we've covered at Law and Crime. And unfortunately, that is saying a lot because we have covered a lot of cases very similar to this. But in this situation, the sheer volume of allegations really sets it apart. And we're going to talk about that. And the kind of allegations that this teacher is facing, for most people, if it was them, I think they would avoid the public altogether. But prosecutors on this case now say these allegations have not stopped Maris Nichols from allegedly violating the conditions of her bond dozens of times. Now, before we get to that part of the story, I want to bring you up to speed on this case because it is shocking and words just don't do it justice with what this teacher allegedly did at this school. So Maris Nichols was reportedly a bio teacher in Douglasville, Georgia. It's about a half hour outside of Atlanta. In fact, she was actually the head of the bio department at Alexander High School. She was also very involved with the football team at the school. You can see this picture here. She's in a jersey with a person who looks like a player. And we also found much more about Maris Nichols. We actually found the Facebook page for the booster club for the Alexander High School Cougar football team. And that's where we found that picture of Maris Nichols. And we also found this post that lists her as the director of player personnel and managers. She writes in this post that the Cougars are putting in work this summer and the players, coaches, and managers are dedicated to making this team the very best. So before we get to how Maris Nichols may end up in jail as this case moves forward, I want you to buckle up as we walk through what she is accused of doing. And of course, these are just allegations at this point, and she is innocent until proven guilty. Now, initially, Maris Nichols was arrested back on May 8th. Police say she was arrested because she allegedly had sex with a student on campus in a closet just days before her arrest. And that's not all. She is also accused of having sex with that student in a 2006 black Hummer. Now, the first arrest warrant says, quote, said accused did having supervisory disciplinary authority over the student, to wit, Maris Nichols, who is a teacher at Alexander High School, did engage in sexual intercourse in a 2006 Hummer. The first alleged incident happened on April 23rd inside a closet at Alexander High School, a closet that, according to investigators, was literally shared between two classrooms. Then you have the second incident that investigators say happened days later. It was over the weekend of May 2nd, and the time that it's alleged to have happened pretty late, between 12:45 in the morning and 2 a.m. at a home in Douglasville, Georgia. And that is where the black Hummer was parked, according to police. Now, Maris was arrested on the 8th of May. She made her first court appearance, and she was granted a $40,000 bond, which she posted, and then she was released from custody. Now, at that time, she was facing 2 counts of sexual assault. And I say 2 because it's obviously incredibly serious, because prosecutors would soon add many more charges and allegations. Now, 2 counts of sexual assault, a teacher accused of allegedly having sex with a student. We have seen so many cases where that can put someone in prison for decades. But then, weeks later, Maris Nichols was arrested again. And this time, investigators said they found evidence she allegedly sexually abused 5 more students. 5. And that includes a female student. Prosecutors say she allegedly sexted the students, telling them what kind of sex acts She wanted them to perform on her. She allegedly sent nude pictures and videos of herself to students, including one that allegedly shows the use of a sex toy. And in one case, she allegedly used a sex toy on a live video call with at least 2 teens under the age of 16. So when it comes to the incident involving the female student in this case, Maris Nichols allegedly sent her a naked picture and encouraged her to watch 50 Shades of Grey. That is, if you haven't seen it, a highly sexualized movie that is based on the very popular romance novel series. Now, prosecutors also say that Maris had sex with a student in the back of his truck at a golf club. And this isn't the same student that she is accused of sexually abusing in a Hummer. That is a different allegation related to this teacher. And then on top of it, you have another twist in this story that shows that Maris potentially was being blackmailed. And she was allegedly being blackmailed by students who alleged that she was operating an account on OnlyFans. So there are some search warrants that have just been unsealed that reveal that investigators reached out to OnlyFans for records. And the warrant claims that students may, and may is an important word here, may have blackmailed Nichols using the allegation that she operated an account on OnlyFans, and they used it allegedly against her in hopes of getting favorable grades in her class. Now, it is unclear if those claims are true because they are just listed in a search warrant, but it's an important part of this investigation. Now, there's another claim in these warrants where there is a video allegedly of Nichols having sex with a student that shows her in a sweatshirt that reads, "Jesus loves you." Now, after her second arrest, Maris was given a bond this time of $74,000. She was able to post that, and she was able to go home. And at that point, she faced 11 total charges, nearly a dozen. So let's go through those charges. There is 1 count of tampering with evidence, 2 counts of child molestation, 4 counts of improper sexual contact by an employee, and 4 more counts of grooming of a minor for a sexual offense. Now, the school district that Maris worked at says that she has been placed reportedly on leave. Now, as you can see as we go through these allegations, they are extensive, shocking. I keep bringing that word up because it's hard not to when you read through all of this. But now there's new information about what prosecutors say Maris Nichols did while she is facing roughly a dozen criminal charges. So this is a new court document that was filed by prosecutors alleging that Maris Nichols violated her bond 85 times. 85. She is supposed to be on house arrest. Documents show she is wearing an electronic monitoring device, which when you think of how those track people, it is frankly wild that she would allegedly violate her bond this many times. Now, Maris, according to the terms of her bond, was only allowed to go to approved activities, and she cannot have contact with unrelated minors. She is also encouraged to go through a mental health evaluation. But prosecutors say they have reports that Nichols has been seen in the community outside of the places where she's allowed to go. There's a report from the electronic monitoring company, according to prosecutors, that says over 27 days, Nichols allegedly committed 38 home curfew violations and 47 inclusion zone violations. Prosecutors say that Nichols allegedly went to retail stores, fast food restaurants, and they also allege that she went to places where children are frequently present. The state says they consider her now a threat to the community, and there are concerns that she could intimidate witnesses in this case. Prosecutors now want Nichols to be held in jail until her trial date, which could be months away. Nichols is next due in court June 29th. Join us now to talk more about this is a criminal defense attorney, Eric Faddis. Always great to have you. I know you're a former sex crimes prosecutor yourself, so a great person to talk to about what is just, I keep saying shocking, which is cliche, but it's like one line after another in this case just kind of blows you away. First off, on the defense side of things, 85 times she is accused of violating conditions of her bond. How do you defend that if you're her attorney?
Ooh, that's a tall order. It's hard to explain away all 85 alleged bond violations. I think one angle that might be considered is this person does not have much criminal history, is my understanding, if any, does not have significant familiarity with the system. She is dealing with so much going on in her life in terms of the national condemnation of her based on these allegations, which have not yet been proven.
Right.
She just didn't quite realize um, all of the strictures of these bond requirements with which she's now trying to wrap her head around and trying to comply with, but not sure how the judge would perceive that.
Right. It's probably a tough argument because, like, on one hand, it's like by the volume, you're like, you had to have known. It's like there's something missing here 85 times. She's accused of going to fast food restaurants, retail stores, just based off what prosecutors are saying. And she had an electronic monitoring device on as well. I mean, typically in these cases, whether it's a case like this, where it's a teacher who's accused of inappropriate activity and sexual abuse, maybe it's another case where someone's able to bond out and then they have an electronic monitoring device. Say someone does one violation. She's driving home from a doctor's appointment. They swing through McDonald's. She didn't know that she wasn't supposed to go to a fast food restaurant. Like, what is the court's stomach for something like that compared to? I mean, obviously, it's going to be, certainly more outrageous when 85 times you're accused of doing this, but just like how bad is one time in some of these cases?
Sure. So, the court's going to look at the nature of the alleged bond violations for sure. So, it's not alleged that she's having contact with minors or texting the alleged victims. That would be extraordinarily serious, that the court would really see a problem with that. This is instead some curfew violations, some zoning violations. While problematic, it's not at the same quantum, the same level as violating some of the other conditions. And the court would look at one of those violations as, oh, that might be a one-off. This could have been a mistake. She went to McDonald's when she wasn't supposed to, not the crime of the century. But when you have something like that 85 times over, it starts to look to the court like this person isn't taking this case seriously.
And when it comes to an electronic monitoring device, like as a prosecutor, when you're piecing things together, and I think it was over the course of 27 days, she's accused of violating the bond this many times. Like, what is the information that comes in where like, what does the electronic monitoring device like actually tell you so you know that she was at a place where she wasn't supposed to be?
Totally. So these devices are pretty technologically advanced. The bond conditions have exclusion zones. I mean, that she can't come by her school or any school at this point. She can't travel to retail stores and fast food joints, things like that. And so what you get is you get information about the GPS coordinates of that monitoring device, and usually they're reasonably accurate. Now, sometimes defense can say, hey, this person was actually 200 yards away from where it says they were, and it was some sort of technological mistake or problem. On the balance, you get a pretty good picture as to where this person has been, and then you sort of piece together, hey, why were they there, and what could have been going on.
Initially, when she was arrested, which was in the first week of May, she was accused of allegedly having sex with a student twice, one being allegedly in a school closet, the other in a 2006 black Hummer. And that was off school grounds, I believe. And like at that point, she was facing two charges of sexual assault. And that is, I feel like we see cases where, I mean, teachers, adults, anybody, whatever their line of work, like that can mean years in prison in and of itself. The fact that she is accused of sexually assaulting or abusing five more students, like like as prosecutors kind of pour through this and make their case against this teacher, like I'm sure that becomes a lot more work for prosecutors as well in trying to figure out exactly what this case is going to look like.
It certainly does. And, Chris, as a former felony prosecutor in a special victims unit where we dealt with sex crimes all the time, one thing you're really looking out for is patterns. There are some cases where it appears to be an alleged isolated incident. And then there are other cases where you could be looking at a serial predator. And those are, that's a tremendous red flag in terms of community safety, in terms of especially not just any predator, but a teacher, someone who has direct proximal access to these vulnerable minor populations. And so you really have to conduct a vast amount of interviews, piece together a timeline. When did this happen? Do we have some sort of documentation supporting it? Are there text messages, emails? Is there surveillance video that might aid our case? So the case becomes more expansive at the same time that it's becoming substantially more grave.
And there's roughly 20 search warrants that have been filed in this case by investigators. They're looking at the digital footprint, which we see that in a lot of these cases. When you hear that many for a case like this, like, is that considered a lot by investigators to serve 20 search warrants?
Oh heck yeah, that's a
Yeah.
tremendous amount. That's usually you're looking at a handful of search warrants. 20, that tells me there are devices, a number of different kinds of devices in the custody of different people, perhaps school
Yeah.
devices, perhaps personal devices. On top of that, they might be serving search warrants on certain companies, like cell phone companies, like internet app companies, things like that, to learn more information and get the really the whole picture here. And it's going to be a Herculean effort simply to sift through the responsive materials, documents, and information from those 20 plus search warrants.
Yeah, it does seem like a lot. You never know though. Like when you're on the outside, you're like, hey, maybe that's just how like these cases go. I mean, certainly you have a lot of alleged victims in this case. One company that did receive a search warrant is OnlyFans. And I think a lot of people know what that is. If not, you can open a new tab while you're watching this video and search for it. Probably not on a work computer. But she is accused of having an OnlyFans. And in this search warrant, it is alleged that students blackmailed her for better grades, knowing that she had an OnlyFans. It hasn't been proven that she did and that this actually happened, but it is part of the case, so we're talking about it. As a criminal defense attorney, like, is that something that could, I mean, she is facing so many allegations and there's so many layers to this story, but just how could that, if that is true, kind of factor into this case and how it goes?
So there are a few ways defense might look at this. One way is that it's completely irrelevant. It has nothing to do with the case, has nothing to do with the allegations. None of the alleged victims are implicated whatsoever in this sort of separate recreational side hustle, whatever you want to call it,
Yeah.
that she's doing. That's got nothing to do with things. It's only going to work to besmirch her character and her name. Judge, we got to keep that out. That's one defense approach. The other defense approach is to say she had people who were trying to extort her. She had people who were trying to use information and leverage to get what they wanted. And if they didn't, they were going to harm her. Does that somehow factor into allegations a person can make? If they're going as far as to say, hey, I'm going to ruin your reputation and your career if you don't give me better grades. Well, another way of ruining reputation and career is by making false accusations. I'm not saying that's what happened.
Yeah.
I'm saying that as defense counsel, you need to at least consider whether that kind of thing could be going on.
One thing I wonder, and it's always delicate kind of talking about this part of it, any sort of bias or stigma in cases like this, because we do see a lot of cases of female teachers who are accused of sexually abusing students. We see a lot of cases of male teachers, all of different ages, accused of sexually abusing students. But there was part of me as I was like reading through this, where I think of like, if it was a male teacher who is accused of sexually abusing like 6 students, that is a lot. Like, do you see in the system, and I know it can vary from state to state, like the fact that she was able to be allowed out on bond twice, is that something if, and it's the ultimate hypothetical, like if genders were reversed here, like how likely perhaps could it have been that she would already be in jail?
The bond part is pretty curious to me.
Yeah.
The fact that a judge looked at these allegations, because as you know, Chris, she was initially charged with 2 counts of sexually assaulting minors, and then the number of counts jumped to 8. There are multiple victims, and a judge still let her out on a relatively modest bond. Would a judge do that if the perpetrator allegedly was male? I'm not so sure. We're talking about a risk to the community. We're talking about a multiplicity of alleged victims. And this person who apparently has access to those folks might have phone numbers, contact information, all of that sort of thing. I think a judge would likely say, hey, the bond needs to be jacked up exponentially. That didn't happen here. Is it because she was a woman? That's a fair question.
Yeah, no, and I know there's like not really like a straight answer to that question, but it is one you think about just with, the amount of victims in a case like this. There does seem to be some digital evidence. We'll see what more the search warrants come back with, but there are allegations in what we've read in some of the warrants that there is a video of her related to some, again, these very disturbing allegations she's facing. Like another thing for the defense in these cases, like if a prosecutor has something where this actually goes to trial and they can just press play on it and it shows her having an inappropriate relationship or contact with someone who is under the age of 16, like how do you handle that?
You think about possible defenses just in the sex assault context. One
Sure.
possible defense is consent. Well, that's out the window because if the person was a minor, they cannot legally consent. So it doesn't matter if they are claiming they wanted that to happen, not a defense. On top of that, you got to look at did the alleged perpetrator have knowledge of that the victim was a minor? If this is some sort of Craigslist meetup where the minor said they were 20 and they were 16, that's one thing. But here it seems like the teacher would know the ages of the students whom she
Yeah.
was teaching, assuming that these alleged victims were students. So the defenses are really being whittled down here. You look at mental health. My understanding is she was ordered to do a mental health evaluation. I'm not sure what that is shown,
Yeah.
but really the defenses are kind of dwindling. You look then at mitigation. How can we limit the exposure if there is no really applicable defense? That's sort of the road you go down.
Because how many of these cases, when you have digital evidence as a prosecutor, will actually make it to trial?
Uh, if there was a video that appeared to clearly show the crime,
Yeah.
um, the defense is really incentivized to not go to trial on that, to really do whatever they can to limit the possible prison time. So I think that those cases are less likely to go to trial. But sometimes when you have a pattern offender and you have what looks like slam dunk evidence, sometimes you try to take that to the house and maximize the penalty because you believe that's in the best interest of protecting the community.
Local media reports, I think it was Fox 5 out of Atlanta covering the story, talked about how she is currently on leave from the school. I feel like in some cases you'll see school districts just fire a teacher moment they're arrested. Other cases do leave without pay. Some do that they're on leave with pay, just depending on what the circumstances may be. Like how could a civil case, like what potentially could like the civil exposure be for a school district if this proves to all be true and you have 6 students who were alleged victims of sexual abuse at the hands of a teacher?
So there very well could be civil liability on behalf of a school district to the tune of millions of dollars. This could be a substantial civil case because we're, like I said, we're not talking about one alleged isolated incident. We're talking about a pattern, according to the allegations, of incidents here. And so what's going to really matter is what the school knew. Were there complaints about this person? Did some students speak out and go to a counselor, go to an administrator, and say, "Hey, there's some weird stuff going on with, Ms. Nichols." Uh, how much of that exists in terms of the knowledge the school had, and then still allowing this teacher to be in their employ? If the school had no knowledge of this, then their liability risk is very low. But if there was at least some complaints, at least some reports, some clues, some indications, we're looking at a potential civil case.
And then I always wonder too, like the inner workings of like a DA's office or a state attorney in whatever state it may be. Like in this case, like if you have digital evidence and you can say like we can go get a conviction tomorrow on this person. Like I mean, we press play on this video and it's over. What's the calculation inside the office though when it comes to okay, we could get a plea deal for this, or we could take her to trial and then we can get her for a lot more.
Totally. So we had, when I was a prosecutor, including the Special Victims Unit, this concept called GORT, GORT, guilty or trial. It's something we only used when we had compelling evidence that we thought was extraordinarily strong. And we had a person who was a tremendous threat to the community, like a pattern serial offender. And
Yeah.
what we would say in those cases to defense is like, hey, this person's the worst of the worst, in our opinion. And the only thing they could do is plead guilty to all the charges and, ask for mercy from the judge, or they can go to trial. But we're not issuing a plea offer. We're not giving them leniency. We're not going to give them a break. I wouldn't be surprised if this would fall into that guilty or trial category from a prosecutor's perspective.
Yeah, and we'll see what happens next. She is presumed innocent as this case moves forward, certainly on the bond part of it. I know she's due in court next week. We'll see if she is taken into custody based off of allegedly violating the rules of her bond 85 times. We'll see what happens next. Eric Faddis, the Mile High Lion, criminal defense attorney in Denver, Colorado. Thank you as always for taking the time to be with us on Law and Crime. We appreciate it.
Great to be with you.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify, and we are also streaming on Peacock. I'm Chris Stewart. We'll see you next time.